Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross Law LLC. I'm a practicing business attorney with over 15 years of experience helping entrepreneurs start and operate their business. Today, I'm going to talk about a frequent question that many entrepreneurs ask. Should I form my LLC first, or should I protect my business name with a federally registered trademark first? This question seems simple on the surface, but making the wrong decision can lead to forced rebranding and avoidable legal expenses. In this video, I'm going to walk you through the differences between an LLC and a registered trademark, how the two work differently to protect your business, and the legally sound order of operations when starting a business. And please, if you'd like to get more helpful legal tips, please ring the bell and hit the like and subscribe button below. It really helps the channel and lets me know you'd like to receive more helpful legal tips like this one. Let's begin with the LLC. An LLC, which stands for Limited Liability Company, is a legal entity that's created under a state's law. In Massachusetts, the law is MGL Chapter 156C, which is called the Limited Liability Company Act. In an earlier video, I talked about the process of forming an LLC under Massachusetts law, and I'll put a link to that video below. However, if you're in a different state than Massachusetts, the statute for forming an LLC is going to be different, and you just need to form the statute in accordance with the laws in the state where you're located. An LLC serves two primary legal purposes. The first purpose is to operate as a completely separate legal entity that is distinct from its owners in the eyes of the law. This means that an LLC can sign its own contracts, have its own bank accounts, be responsible for its own debts, and is held accountable for its own actions. The second purpose is to provide personal asset protection for the owners of the LLC, which are called its members. This means that generally speaking, if the LLC owes money to a creditor, the creditors can't pursue the personal assets of the owners to cover these debts. Instead, the only personal assets of the owners that are at risk is the amount of capital that the owners invested in the business when they were starting up the business, or that they have contributed over time to keep the business up and running. Beyond that, the owner's personal assets should be safe so long as the rules for the entity are followed and you don't commingle assets and the owners don't commit any personal torts in connection with operating the business. Now, the important thing to note here is that from a legal standpoint, an LLC is all about being a separate legal entity and providing liability protection for its owners and has nothing to do with business branding. When you file the LLC formation document with the Secretary of State in a particular state, the formation document will need to identify a name for your LLC, such as Coco Consulting LLC after my dog Coco. Then the Secretary will investigate whether any other entity in that particular state is using that name or a confusingly similar name, but will not investigate whether that name is a registered trademark or whether your use of the name infringes on someone else's brand. And if your LLC is approved by the Secretary, this only means that no one else will be able to register an entity in that state with that name so long as your entity continues to exist. But an important thing to keep in mind here is that this does not stop someone else from setting up an LLC or a corporation in another state with the exact same name. So even if you form Coco Consulting LLC in Massachusetts, this will not stop someone from forming a Coco Consulting LLC in New York, Connecticut, or any other state in the United States. Now, if you're not satisfied with this and want more brand protection for your business name and want to stop anybody else from using your name across the United States, you need to think about registering for a trademark with the United States Patent and Trademark Office, also called the USPTO. So let's turn to trademarks. A trademark is any type of distinctive word, design, phrase, logo, symbol, or anything else like that that identifies the source of goods and services and distinguishes your goods and services in the marketplace from competitors. Its primary legal purpose is to prevent confusion in the marketplace and protect your brand from being copied by others and used with someone else's goods and services. Think of something like the golden arches of McDonald's or the Nike swoosh. Everyone who sees those symbols knows the goods or services that are associated with those symbols and what to expect from them. Now, the most important feature of a trademark is that if you have one in connection with a particular class of goods and services, you have the right to exclude someone else from using the same name in connection with the same types of goods and services. So, for example, if I have a trademark to the name Coco Consulting in connection with the services of business consulting, then I can stop anyone else from using the same or a similar name in connection with business consulting. Of course, to do that, I'd probably have to file a lawsuit against them, but I have the right to do it so long as I have a trademark in the name, and then I can claim that the other business is infringing on my trademark. Related to this, however, is that even if I have a trademark in Coco Consulting for business consulting, I probably can't stop someone from using the name Coco Consulting in connection with exercise fitness consulting or something similar to that. And the reason for this is that trademarks are limited to a particular class of goods and services that they are being used with, and that's it. So even if I have a trademark in Coco Consulting for business consulting, someone is free to use the name Coco Consulting in connection with a completely different class of goods or services. And it's hard to claim that business consulting and exercise fitness consulting are similar types of services and that they're provided to the same types of customers, such that the customers would be confused about the source of the services. Now, one common misconception about trademarks is that in order to have one, you need to file an application and register for one with the United States Patent and Trademark Office, which is also called the USPTO. But that's not true. You automatically have a trademark as soon as you start using your company name or a company logo in commerce, but the protection is very narrow and is only limited to the geographic area where you sell your goods and services. So, if I simply start using the name Coco Consulting in connection with providing business consulting to Boston businesses without filing to register a trademark, I have some trademark rights to the name in Boston, but I don't have trademark rights anywhere else. These rights are known as common law trademark rights, and every single business that operates under a business name in commerce has those rights, even if they don't file for a trademark with the United States Patent and Trademark Office. Now, in order to obtain trademark rights over a broader geographic area all over the United States, you need to file an application and register the mark with the USPTO. If it's granted, you have exclusive rights to use the name everywhere in the US and will be able to stop competitors from using the name in connection with the goods and services that you offer and that the trademark is registered with. There's also a whole host of other benefits that you get from registering your trademark, such as creating a public record of ownership of the mark and making it less expensive to enforce the mark in case you need to file a trademark infringement action against someone else. Plus, as I explained in an earlier video, you don't even have to be using the mark in commerce to apply to register for a trademark with the USPTO. You can file for a trademark with the USPTO under what's called an intent to use application to make sure that the mark is available before you spend thousands of dollars in marketing costs and actually offering the goods and services in commerce under that mark. So let's get to the million-dollar question. Which one comes first? For the vast majority of entrepreneurs, the answer is crystal clear. You should form your LLC first before you file for your trademark application. And the reason for this is critical and simple. One of the things that the USPTO is extremely strict about is that the applicant for a trademark application must be the legal owner of the trademark on the day that the application is filed. And the owner of the mark is the party who controls the quality of the goods and services that are being named in the application and will be sold under that mark. So if you intend for your LLC to be the business selling the products or services under your brand name, then the LLC is the rightful owner of the trademark, and the LLC should be identified in the application for the registered trademark. And here's the kicker. An entity can't own property or be named in an application if it doesn't exist. If you file a trademark application and list your not yet formed LLC as the owner, that application is void from the start because the owner doesn't legally exist on the filing date. Let me say that again, because it's the most important takeaway. The LLC must exist before it can be named as the owner on a federal trademark application. And if you file for a trademark application under an LLC's name that doesn't exist, the application will be void from the start, and you have just wasted a bunch of money in trying to file for a trademark application. Now, you might be thinking, well, I'm going to be one of the owners of the LLC, so I can file for the trademark now and transfer to the LLC later, and so I don't need to have the LLC existing from the date I file for the application. While that's technically possible, there's usually a couple of problems with it. First, as part of your trademark application, you're going to need to identify your personal name and your address, and this information will be part of the public record in the USPTO database associated with the trademark. For privacy purposes, many people don't like having that information publicly available associated with their business. Second, if you're part of a multi-member LLC, having one member identified as the trademark owner as opposed to the LLC can cause all sorts of problems if the members are no longer able to get along in the future. The member identified as a trademark owner with the USPTO will be the presumptive owner of the trademark, and the other members will have no rights to it. This may seem like it's not a problem in the beginning when there are no issues among the members because everyone is getting along, but it can become a real problem in the future if the members are no longer able to agree on anything and want to dissolve the LLC and figure out what to do with all the assets of the LLC. Third, to transfer ownership of the trademark from you to your LLC, you will need to file additional paperwork with the USPTO called a trademark assignment, which has to be drafted perfectly and then recorded with the USPTO, costing you extra filing and legal fees. It's just asking for headaches, and things can go wrong, and it will cost you a lot more money to assign your trademark back to your LLC in the future. So, in light of all these potential issues, the clean, correct, and legally solid path is to form the LLC first and then file the trademark application with the LLC identified as the owner of the mark. So what does this look like in practice? Here's your step-by-step guide to getting it right. Step 1, do some detective work. If you want your LLC name to be the same name as the brand name that you plan on using in connection with the sale of your goods and services, then you have to do some homework to make sure that the name is available. And there are a lot of places to look to see if the name you want to use is already in use by someone else. One place is with the U.S. Patent and Trademark Office website, where you can run searches on their database to see if anyone else already has a registered trademark or if someone else has filed for a trademark in connection with your name. I'll put a link to the USPTO website where you can run searches on the name. However, if you're really serious about making sure that no one else is already using your name in connection with a registered trademark or a trademark application, I highly recommend you speak with an attorney who'll be able to run a full-fledged trademark clearance search for you to make sure that the name is available to be registered as a trademark. It will cost you a little more money, but they're much better at running these searches than you are, and may be able to turn up names that you might not be able to turn up just by running names yourself in their database. In addition to searching the USPTO website, you also want to run Google searches for your name in connection with the class of goods and services that you're planning on offering, and you also want to search various social media websites such as Facebook, Instagram, TikTok, and all the other ones out there. And there's lots of different social media websites. You want to run searches on all of them to make sure that your name is available, especially in connection with the goods and services you want to offer. You also want to run searches on the various domain registers to make sure that the domain name you want to use is available. For example, if I was starting a business called Coco Consulting, for my business consulting business, I'd want to run searches on the various domain registers to make sure that the name cococonsulting.com is available. If it's not available, then that may be a sign that there's already a business out there called Coco Consulting that's offering consulting services in some fashion. Step 2, form your LLC. Once you're reasonably confident the name is available, it's time to create the LLC that will own the trademark. Go to your state Secretary of State website, file the paperwork, which is often called a certificate of organization, pay the filing fees, and officially create the LLC. Once it's approved, your LLC is a real legal entity capable of owning assets like a trademark and filing a trademark application. Now, of course, there's a lot more that needs to be done in connection with starting your LLC, such as getting an EIN, opening a bank account, and drafting an operating agreement. Don't skip these steps if you want the LLC to work properly and shield your other personal assets from the debts and liabilities associated with the business. Speak with an attorney if you need some help. Step 3, file your trademark application in the LLC's name. Once the LLC officially exists, it can file a trademark application with the USPTO. I highly recommend that you work with an attorney through this process, as it can be complicated and there are various steps you need to do to make sure that your trademark application is filed properly. The first step, if you haven't already done so, is to run a full trademark clearance search. And if the name is clear and available, you can then file the trademark application with the USPTO. In the owner section, you must list the LLC's exact name, such as Coco Consulting LLC, and for entity type, you want to select limited liability company and specify the state where it was formed. You will also need to identify the specific class of goods and services associated with the mark, and you need to be very careful when identifying the class of goods and services. The cost of trademark application is at least $350 per class of goods and services, and the total cost will depend on the description that you choose and the number of classes that you choose in connection with the trademark application. Finally, an officer of the LLC, like a member or a managing member, should sign the application on the LLC's behalf, or if you're using an attorney to file the trademark application, the attorney can sign on behalf of the LLC. By following this three-step process, search, form, and file, you ensure your trademark application is valid from day one and you're building your brand on a rock-solid legal foundation. Look, I get it. For a lot of startups, the budget is tight. So what do you do if you can't afford to both form an LLC and file for a trademark right away? This is where you have to weigh the risks and make trade-offs depending on what's most important to you, both in the short term and the long term. Some might suggest prioritizing the trademark filing if protecting the brand name nationally is your absolute top priority and your business isn't inherently risky. In that case, you'll be operating the business as a sole proprietorship and you'll file the application in your personal name as a sole proprietor. Although not ideal, this is acceptable, especially if you're only filing an intent to use application to reserve the name before you even started selling anything. But you have to understand the trade-offs. First, you're operating with zero personal liability protection until you form an LLC. All business debts and legal risks associated with the business fall squarely on your shoulders. Second, you're creating future chores and hassles for yourself. Once you do form the LLC, you absolutely must formally assign the trademark from yourself to the new LLC. If you forget to do it, you, the individual, will technically own the brand while your company is using it. A legal mess that can cause huge problems later and will still leave you open to personal liability in connection with the goods sold by your business. My general advice, even for businesses with a national presence from day one, is to prioritize the LLC. It gives you immediate asset protection and shields you from the debts and liabilities associated with the business, which is critical, especially if you have multiple employees who are working for you. You can then save up and register the trademark with the uspto under the LLC's name as soon as possible. The risk of someone grabbing your brand name is real, but the risk of losing your personal assets in a lawsuit can be life-altering. Also, once you start using the name in commerce, you will automatically have some common law trademark rights so long as you are the first one to start using the name in commerce in connection with your class of goods and services. Weigh these risks carefully for your specific situation. And if you have any questions, I advise you to speak with an attorney who can help you evaluate the situation and determine what's best and help you determine what's best for you and your business. So let's circle back to the entrepreneur's dilemma. LLC or trademark first? The legally sound and most efficient path is to first form your LLC and then file your federal trademark application with the USPTO with the LLC listed as the owner. This approach aligns with the USPTO's strict ownership rules and saves you from filing a void application or dealing with complicated ownership transfers down the road. Remember, your LLC is a liability shield and the trademark is your brand shield. Using them in the right order ensures both are built to give you maximum protection. Getting this first move right isn't just about checking a box. It's about locking down ownership of your brand from the very beginning and setting your business up for secure long-term growth. If you found this episode helpful, please make sure to like, subscribe, and share it with other Massachusetts entrepreneurs. And if you have any questions or want me to cover another topic, please make sure to drop a comment below. Thank you so much for watching Small Business Legal Tips. I'm attorney Mark Bross, and I'll see you in the next episode.